of private companies on human rights in Guyana, and this was a hearing requested by civil society organizations. So here's how we're going to spend the hour and a half together. We will have civil society will speak for 20 minutes. The representatives of the state will speak for 20 minutes. The commissioners will have, and the commission, 20 minutes or less to ask questions or make comments, and then we return to CSOs for 12 minutes and the state for 12 minutes. I would like to acknowledge the presence of Minister Barrett, who is here with his team, and thank you, representatives of the state, for being with us virtually. We also have representatives of the state here physically with us, and I also welcome the representatives of civil society. Before we begin, if you can allow me to do a little advertising, this year, 2024, represents the 65th anniversary of the Commission. It's a commission that has been very devoted and committed to the defense and promotion of human rights in the Americas and the Caribbean. And we have what we think is an enviable record of achievement. Over the last 65 years, acting with the input of thousands of individuals, groups and peoples of the region, we have undertaken more than 100 on-site visits. And with every visit, we had to do a report. We have issued over 1,000 precautionary measures, more than 750 merit reports, 220 friendly settlements, and we have sent 377 cases to the Inter-American Court on Human Rights. So I think you all will agree that's an enviable record of work. All of this with victims at the center of our work and as our priority. Securing the rights of peoples of the region is our priority, but also, of course, in a complementary way, working with the states to ensure that they can comply with their obligations to which they have voluntarily agreed to ratification of treaties is also a big priority of the Commission. So I'm sure you all celebrate with me the 65 years of work of the Commission. I also just want to say something about inclusivity and how we're going to function in this hearing. To ensure that the hearing is inclusive, we ask that all participants, before you speak, to say your name, to say your position, and the organization or institution that you represent. Subsequently, whenever you take the floor, please repeat your name. And we ask that so that those who are visually impaired can identify who is speaking. Likewise, we remind you that those who are online, you have Zoom subtitles which you can turn on, and you can also manage the size of the font or the display size as you need. For those who are not following us on Zoom but want to follow us, I remind you that we do have live stream on Facebook as well as on YouTube, so please do that. So with that, I want to turn to civil society to make your representation. I want you please to pay attention to the clock. I would not want to interrupt anyone and give them time. So please, you can self-regulate by looking at the clock online. Over to you. Civil society? We're not hearing, whoever's talking, we're not hearing anything. Are you all hearing?
Yes.
Okay.
Danuta Radzik, GuyanaOilAndGasChange.org. Can I start?
Please do.
Yeah, so good afternoon all. Many thanks to IACHR for granting us the opportunity to present this afternoon. Right to a healthy environment, rule of law, and justice in oil and gas industry. The oil and gas industry in Guyana, with large commercial volumes, moved rapidly from exploration to drilling to production in a country with limited knowledge, expertise, inadequate policies, or specialized institutions for monitoring and regulating this industry, and with a production sharing agreement highly favoring ExxonMobil over Guyana's interest. The Environmental Protection Agency, EPA, as a regulatory agency, has a duty to ensure and guarantee the substantive and procedural environmental rights enshrined in Guyana's constitution, environmental protection.
I'm sorry to interrupt you, Ms. Radzik, but we're having some trouble here. Let me just figure out what it is. Give me a second. Okay, so Ms. Radzik, the interpreter is saying you're speaking too softly and too speedily.
Too softly.
No, it's not about the volume. Apologies.
Well, I'm not sure how
Well,
to do that.
Just talk louder and talk slower.
Oh my God.
Just talk louder and talk slower.
I'm talking very loud. All right, so shall I start from the beginning?
I think so.
Right to a healthy environment, rule of law, and justice in the oil and gas industry. The oil and gas industry in Guyana, with large commercial volumes, moved rapidly from exploration to drilling to production in a country with limited knowledge, expertise, inadequate policies, or specialized institutions for monitoring and regulating this industry, and with a production sharing agreement highly favoring ExxonMobil over Guyana's interest. The Environmental Protection Agency, EPA, as a regulatory agency, has the duty to ensure and guarantee the substantive and procedural environmental rights enshrined in Guyana's Constitution, Environmental Protection Act, and binding human rights treaties, including the right to a healthy environment, public participation, access to information, and access to justice in environmental matters. EPA's failure in its duties and obligations re the oil and gas industry. The failure to employ highly specialized and experienced petroleum, geological, and environmental engineers for the EPA has resulted in a lack of expertise and capacity to protect the environment and health and well-being of Guyanese people. The EPA has waived exempted EIAs for at least 10 onshore projects, including a gas-fired power plant, Schlumberger's radioactive source storage and calibration facility, Goya's waste treatment facility, Tiger Rentals waste facility, Schlumberger and Halliburton's liquid drilling mud plants, etc. Of the 19 EIAs, environmental impact assessments, on the EPA website, there is not one for onshore oil and gas projects. Section 11 of the Environmental Protection Act outlines projects requiring EIAs. These include the extraction of natural resources or any project which may significantly affect the environment. The hazardous nature of oil and gas onshore projects warrants EIAs. Ghana has two appeals bodies, the Environment Assessment Board, the EAB, and the Environmental Appeals Tribunal, never established. The functioning EAB's lack of independent experts and environmental professionals instead of appointed high-level government public service, some linked to the oil and gas industry, calls into question its independence and expertise. If the EAB upholds EPA rulings, there is no other recourse except through the courts, an expensive, difficult, lengthy process, and an impediment to access to justice. Even though Ghana is currently producing approximately 650,000 barrels of oil per day, estimated annual project waste for 2 oil projects for 3 years was 15,310 metric tons, or close to 34 million pounds, 85% of which is to be transported onshore. However, there is no EPA information on hazardous waste, chemicals used, treatment standards, or shipment of waste as required by EPA's recording and reporting form for all companies generating hazardous waste. As the oil and gas industry expands tenfold, amounts of hazardous waste will increase, with additional risks to health, safety, and well-being of Guyanese communities. Increasing river and ocean traffic increases risks of hazardous waste spills into the Demerara River and Guyana's marine environment, which would be an unprecedented environmental disaster. We see the devastation from Tobago's oil spill happening right now. Access to justice in environmental matters. In October 2023, the Attorney General and Minister of Justice asked the courts to impose higher costs to prevent citizens from filing, in inverted commas, frivolous public action cases related to the oil sector. Notice for judges to comply with this is particularly egregious. Specific environmental risks. Schlumberger, who operated a radioactive source storage and calibration facility with an injunction and cease order still in place, also operates a liquid mud plant and dry bulk facility situated near to residential properties and communities without an EIA or known environmental permit. According to Schlumberger's chemical safety sheets, risks of water-based drilling fluids include acute oral toxicity, acute inhalation toxicity, category 4, skin corrosion, serious eye damage, produces hazardous combustion products, and causes cancer and reproductive toxicity, according to the U.S. State of California Safe Water and Toxic Environmental Enforcement Act. The same chemical safety sheets identify 42 toxic and polluting chemical substances used in Schlumberger's drilling fluids mud plant. 13 of these are classified by OSHA, NTP, and IARC Group 1 as known human carcinogens. 25 are classified as immediately dangerous to human life and have an advisory not to be allowed to enter drains, watercourses, soil, and not to be released to the environment. 21 are highly combustible with unusual fire and explosion hazards, including that dust or fumes may form explosive mixtures in air. Schlumberger has no fire prevention, radiation exposure, chemical spill, hazardous discharges into air, water, or soil evacuation plan for communities, the East Bank roadway, schools, health centers, water wells, businesses, or FBOs surrounding the Schlumberger facility. Thank you.
Greetings of tranquil peace, Elizabeth Dean Hughes, co-applicant, member of Civic Society, Guyana. I will approach the gas to energy project from the aspect of a lack of adherence to the rule of law and to ask the Honorable Commission to request information from the Government of Guyana. The GTE project in its current format has been so since 2020 without a feasibility study for the Wales location, nor any location with 25 kilometers of onshore pipeline. And there is no updated feasibility or pre-feasibility study since COVID-19 or the Ukraine war, which has skyrocketed the world prices. While we wait on the promised documents to be laid in the National Assembly, human rights are being destroyed under a lack of consultation for this project, a lack of the right to free, prior, and informed consent, failure to provide adequate information, lack of access to any information, and deals in non-disclosure inter alia. A few additional questions for the Commission to ask the Government of Guyana in light of the recent media reports from the international media reports, Reuters in particular, from the consultant head of the task force who has admitted to a delay in the project's timeline, due in part to foundation issues or geotechnical challenges. Yet, it is claimed by him that this project will be brought in on time and on budget. We're not sure which time or which budget, but the questions are, what are the additional costs to the project for these foundational and geotechnical challenges? What are the additional costs to the project for the delay to Guyana? And this project is only serving 68% of the population in the Demerara-Berbice interconnected system. What are the costs or financial implications for the pipeline's completion in 2024 and the NGL power plant startup in 2025? On the face value of the contrary to law and improper as adjudged in the Razik et al. Versus EPA et al. Case, environmental permit, and despite many letters written, there is no information on the rules governing the ExxonMobil's community grievance mechanism. There is no information on the stakeholder engagement plan nor the baseline study. All of these are listed in the environmental permit, the illegal environmental permit. And further, what is the proposed process and procedure to land the yet to be crafted gas leak management plan into the environmental permits? And the last question in this lot is, when will the land usage for Hermitage rails be changed from agricultural to whatever it needs to be for this gas energy project? Albeit the Attorney General and other high government officials have asked the courts and continue to refer to those of us who are seeking adherence to the rule of law as busybodies, nuisances, loonies, crazies, and other choice words, the Environment Appeals Tribunal, as mentioned by my other co-applicant, is yet to be established despite repeated requests. This refusal limits who can appeal EPA's decisions. In conclusion, I would like to highlight some aspects of the TikTok video which was shared at our application. I would like the timeline to be followed here. So the gazetted order was issued in January, printed for the properties in the right-of-way. In February, one of the owners in the right-of-way filed a case which challenges the whole process. Despite two previous attempts in October, the ExxonMobil, along with the government of Guyana officials from the Ministry of Natural Resources, Ministry of Works, and surveyors, entered illegally onto the land, and that's the TikTok. Yet in October, the government of Guyana, through the Attorney General, applied for valuation of the same land, and the Registrar of Deeds, who was previously charged with fraud, made an annotation on that transport before the final determination that challenges the whole process and procedure of the right-of-way claim of the properties. Further, there are 2 sheets files for one property, only one of which corresponds to the order which was issued in January. This is the legal arena in which the GTE project is being applied across the board. There are other cases, and one very notable one is the one that challenges the constitution of the EAB, the Environmental Assessment Board, and its decision to waive the EIA. I would like to thank the Commission for this opportunity, my co-applicants, and the government of Guyana for any answers it can give to us before it files into the National Assembly. Thank you.
Greetings, Commissioners, IACHR technical team, and participants. Thank you for scheduling this hearing, which gives us the opportunity to air some of our deep concerns about developments in Guyana. I begin with a brief statement about Red Thread. Red Thread was established in 1986 as a multiracial independent women's organization not affiliated to political party, and which begins with grassroots women's lives across divides of race, age, sexuality, ability, and other differences. Our work is always carefully structured with this principle in mind, focusing on how issues like cost of living, defending the rights of domestic workers and security guards, usually women, domestic, sexual, state, and other forms of violence, and reproductive rights and health provide opportunities for grassroots women to come together across different communities to break silences and learn from each other in ways that benefit them and their communities and help build relations of trust. With the advent of oil production, the Guyanese public was told that significant inflows of money would be available for development, that Guyana would become the region's Dubai and more. Expectations in the communities were that the national standard of living would improve as the oil wealth was used to improve lives and livelihoods. However, when we compared our household budgets, we could not find the improvements that were promised. In fact, for the grassroots women with whom we organize, the cost of living was going up, house rents were through the roof, and the price of food was prohibitive. So we began to compare prices across communities for essential household items and for food, which resulted in a couple of newspaper columns. The Stabroek News, a national newspaper, later began a weekly feature of people across the country, commenting on the high prices for essentials and how they were surviving. We called on experts and technicians to explain to us the information about the oil production arrangements that were in the public domain, since the published exchanges were way over our heads. We learned about the potential environmental consequences of deep ocean drilling that was happening, and we learned about the legal responsibilities of the Environmental Protection Agency in relation to the oil industry. We've been calling on the government of Guyana, and we continue to call for rule of law compliance in oil and gas to be ensured by our government. One aspect of the industry and the EPA law-breaking was the subject of an application filed by Frederick Collins and Godfrey White for orders of mandamus, prohibition, and declaration. The concern which we share is that the environmental permit with the oil company required a parent company full liability guarantee in the event of any production disaster, which clause has not been enforced by the EPA. As things stand, the oil company is liable only to the extent of their insurance coverage. To quote a small section of the judge's ruling, the antecedent circumstances giving rise to these proceedings for judicial review has disclosed the existence of an egregious state of affairs that has engulfed the Environmental Protection Agency in a quagmire of its own making. It has abdicated the exclusive statutory responsibilities entrusted to it by Parliament under the Environmental Protection Act 1996 and the Environmental Protection Regulations 2000. The EPA has relegated itself to a state of laxity of enforcement and condonation, compounded by a lack of vigilance, thereby putting this nation and its people in grave potential danger of calamitous disaster. Remarkably, this judgment, which sought to protect this country and people, was appealed by the EPA and the government. The orders were stayed by a higher court, and Exxon subsidiary, EEPGL, was ordered to lodge $2 billion insurance with the EPA. Whether or not this has been done remains a secret. We are very concerned about the appearance and maybe the reality that the government of Guyana is more concerned with appeasing the oil company than protecting the rights of our people and our environment. Thank you.
You have 1 minute, 20 seconds. Go ahead.
So, to conclude, what's our overarching right? So, to conclude, what's our overarching objective here today? It's simply our constitutional right to a healthy environment and the restrictions we face in access to justice in related matters of public interest. The right to our role as citizens and environmental defenders enshrined in the Constitution is being denied by state actors through demonizing and insulting us and NGOs such as the Guyana Human Rights Association, Transparency Institute of Guyana, Inc., and Red Thread, as well as publicly calling activists, environmental defenders, and other stakeholders busybodies, obstructionist, unpatriotic, anti-development, and other derogatory terms, thereby creating an atmosphere of fear and intimidation. Yet, focusing on just 3 constitutional articles gives powerful guarantees to the role and right of Guyanese citizens and their organizations to fully and legitimately participate in such matters. Article 13 of the Constitution states, the principal objective of the political system of the state is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations in the management and decision-making processes of the state, with particular emphasis on those areas that directly affect their well-being. The Constitution also mandates, quote, every citizen has a duty to participate in activities designed to improve the environment and protect the health of the nation. Article 149J, in its turn, recognizes the right of every person to an environment that is not harmful to his or her health or well-being. Access to information is guaranteed within the framework of the freedom of expression. The Constitution states, quote, no person shall be hindered in the enjoyment of participating in the management and decision-making processes of the state, and constitutional guarantees are provided for in case of violation of such rights thereof. Article 149C, which is listed under Title I, Protection of Fundamental Rights and Freedoms of the Individual, reinforces this right. It sets out that, quote, no person shall be hindered in the enjoyment of participating through cooperatives, trade unions, civic or socio-economic organizations of a national character.
I'm so sorry, Ms. Radzik. Can you please wrap up?
Processes of the state. Article
She's not hearing me.
149D.
Ms. Radzik, I'm sorry to interrupt you, but you have to wrap up.
The state shall not deny to any person equality before the law or equal protection and benefit of the law. Finally, this is where we stand today before the IACHR, powered by the courage of our convictions, protected by the Constitution and rule of law, which we fight to uphold, and committed
Okay,
to sustainable, honest,
I think you have to come to an end, Ms. Radzik.
that encompasses a
we-
harmful environment, health and safety measures, and the right to justice, fairness, and well-being of the Guyanese people.
Yeah, I'm sorry you didn't hear me, but you did go well over your time. I would like to I would like to invite the representatives of the state to make their presentation now. Thank you very much. State, can you please go ahead, Representative State?
Thank you. Good afternoon. Esteemed members of the Inter-American Commission on Human Rights, distinguished ladies and gentlemen, it is with a profound sense of duty and commitment that the government of Guyana takes this opportunity to address key issues raised in the January 24, 2024 correspondence from the Commission regarding the impact of private companies on human rights. Although the government of Guyana has taken note of the fact that the correspondence in question did not specifically emphasize which rights under the American Convention on Human Rights have purportedly been abrogated, the government considered it important to attend this public hearing to enhance the awareness of all concerned on the propriety of its actions, legal, regulatory, technical, and otherwise with regards to the growing oil and gas sector. This we will do by addressing 5 key points arising from the correspondence. These are the legal framework for the environmental regulation of the petroleum industry, the environmental assessment process, access to justice in environmental matters, the technical prowess of the environment regulator, and access to environmental information. Foremost, it must be emphasized that Guyana boasts an extensive and forward-thinking legal framework for environmental regulations. While there can be no denying the fact that there is room for amendments, even in its current state, Guyana's local environmental laws continue to present a model for other countries around the globe, which have yet to make express provision for a constitutional right to a healthy environment. Whereas in many other petroleum producing states, the citizens' right to a healthy environment is non-justiciable or can also be domestically recognized, where a court is persuaded that it is implicit in other express justifiable human rights, such as the right to life. In Guyana, the right to an environment that is not harmful or human health or well-being is expressly provided for by the Guyana Constitution and enjoys full judicial protection. Article 149J of the Constitution of Guyana declares that everyone has the right to an environment that is not harmful to his or her health and well-being. Also continues to provide that the state shall protect the environment for the benefit of present and future generations through reasonable legislative and other measures, secure sustainable development and the use of natural resources while promoting economic and social development. This commission is asked to take note of the fact that the people of Guyana, through their constitution, have agreed to pursue the goal of sustainable development. This, as defined in the 1987 Brundtland Report, Our Common Future, and reinforced in Guyana's local laws, means development which meets the need of the present without compromising the ability of future generations to meet their own needs. It also poses a fair balance between environmental sustainability, social development, and economic development, and the pursuit of any one of the three pillars at the expense of another. In this vein, the Environmental Protection Act, Chapter 2005, requires the principal environmental regulator, the Environmental Protection Agency, EPA, to take such steps as are necessary for the sustainable use of the nation's natural resources. Sustainability is our watchword as a people. And as such, as a government, we cannot continue the elevation of environmental sustainability above social and economic development. We must balance all three. One of the key management tools utilized by the state to ensure the sustainable development of petroleum resources is the environmental assessment. Contrary to what the correspondence before this commission has indicated, the legal framework in Guyana allows for many forms of environmental assessments, of which one is the Environmental Impact Assessment, EIA. Indeed, there are many who hold the incorrect view that each and every project that touches and concerns petroleum development must be assessed by way of an EIA, simply because of the resource that is involved. However, this is not so. It is only where it is determined that a project may significantly affect the environment that an EIA is required. Precisely, this determination was made with respect to Liza 1 and Liza 2 projects, the Payara project, the Yellowtail project, and the Waru project, and so forth. It is not made in every case, nor does it need to be in order to guarantee environmental sustainability. The courts in Guyana have long reasoned that EIAs are not mandatory in respect of oil and gas projects, but rather the decision as to when an EIA is required is to be made on a case-by-case basis by the Environmental Protection Agency in accordance with the Environmental Protection Act. This same position was reinforced in a judgment earlier this week by the Supreme Court of Guyana in favor of the EPA. That is the Danuta Razik and others versus EPA and others. It must be emphasized that the government of Guyana recognizes a key aspect of the environmental assessment process is public participation, a form of which is consultation. This involves giving the body consulted a fair and proper opportunity to understand fully the matters about which it is being consulted and to express its views on those subjects. With the consulted thereafter considering those views properly and genuinely, precisely this is done during the EIA process. Contrary to the contentions made in correspondence before this commission, as it relates to the gas to energy project, members of the public were engaged through notifications, opportunity to make submissions, opportunities to attend scoping meetings, consultations, disclosure meetings, and many other engagements. Even so, as it is widely recognized across the world, adequate consultation is not evidenced by a final decision that is on all fours with everything every citizen indicated, each citizen indicated or expressed during the process. This can never be possible. As such, the EPA remains guided by the judicial guidance, which indicates that 1 is sufficient if those affected or likely to be affected are put into a position that allows their view and opinions to be heard, to be ventilated fully, and that those views and opinions are considered properly in the decision-making process. At the end of the environmental assessment process, whether by way of an EIA or cumulative effects only, an environmental monitoring program, EMP, or otherwise, once a project is approved, an environmental permit disclosing conditions which are reasonably necessary for the protection of human health and environment is issued. In the case of the gas to energy project, among other things, this meant conditions related to gas leak management and gas integrity management. The absence of the language preferred in the correspondence before this commission, a gas leak management plan, gas integrity management plan, does not in any way indicate that environmental permit conditions pertaining to gas leak management and gas integrity management. Contrary to the intimidation level against the state of Guyana with respect to citizens' access to justice in environmental matters, the citizens of Guyana continue to enjoy their right, unhindered. In addition to the Environmental Assessment Board, EAB, which is an independent quasi-judicial body established by the Environmental Protection Act, the Supreme Court of Guyana, and ultimately the Caribbean Court of Justice perform a supervisory role over the EPA. Citizens are in no way disenfranchised by the absence of an environment appeal tribunal, because any matter with the EAT would have been competent to hear, could be and have been heard by the Supreme Court of Guyana and ultimately the Caribbean Court of Justice. Further, in keeping with Article 8.3 of the Regional Agreement on Access to Information, Public Participation, and Justice in Environmental Matters in Latin America and the Caribbean, the citizens of Guyana enjoy broad active legal standings in defense of the environment. This has been long recognized by the courts in Guyana and was recently reinforced in a judgment given by the Supreme Court in favor of the EPA, Razik versus EPA. Any contention alleging a clog in the citizen's right to freely access a fair and independent justice system is truly not true. No such finding has ever been made by the court of competent jurisdiction, and there is nothing to show any bias in favor of multinational cooperation in the environmental decision-making process in Guyana. There has never been any differentiation of treatment of persons on the basis of economic standing, nationality, or otherwise. This is never a consideration, nor can it be. The right to protection of the law guarantees every citizen adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power, and ensures them the right to access the court and other judicial bodies to demand effective relief to remedy any breaches of their constitutional rights. The statutory mandate of the Environmental Protection Agency is clear. Taking such steps are necessary for the effective management of the environment. It is precisely what the EPA has been doing without fail ever since the discovery of petroleum resources and its subsequent development, commencing production in December 2019. The EPA continues to consistently invest in the development of its current workforce through specialized training initiatives in collaboration with the government of Guyana. Contrary to what the correspondence before this commission contends, external fundings or grants are only intended to enhance monitoring and enforcement capabilities. This cannot be taken as endeavors to its recruit a specific number of persons specialized in a particular field. There is nothing to indicate a lack of technical competence or capacity within the agency. Rather, the EPA continues to demonstrate its ability to maintain competent and sufficient staff to support the fulfillment of its statutory obligations. The Environmental Protection Act provides for a register of information to which every member of the public has access. Understandably, and as with all human rights, there exist reasonable limitations as to the amount of details that may be provided, the timeline within which the public can expect the information to be available, the time during which the public may access the register. Contrary to claims made regarding the inexistence of data regarding petroleum operations, the unavailability of environmental permits, and so forth, data and environmental information remain available via the EPA's Register of Information. Access simply necessitates compliance with the legally established procedures for same. For instance, any member of the public could have consulted the EPA's register and confirmed that the liquid mud plant with 32 large tanks, which the correspondents suppose may be operating without an environmental permit, is in fact fully permitted by the Environmental Protection Agency. In conclusion, whilst for some, the only satisfactory decision regarding Guyana's oil and gas industry would be a complete cessation of all petroleum activities such as extreme determination. Such extreme determination would be contrary to the legal regime as set out both nationally and internationally. In addition to the clear expression of the goal of sustainable development as set out in the Guyana Constitution, the government of Guyana recognizes the principle of sovereignty over natural resources, which embodies the right of states and peoples to dispose freely of their natural resources. We also consider the Stockholm Declaration, which recognizes that developing countries need to direct their efforts to development, bearing in mind their priorities and the need to safeguard and improve the environment. Further, we are conscious of the United Nations Framework Convention on Climate Change, which acknowledges the fact that developing countries especially need access to resources required to achieve sustainable social and economic development. And that economic development is essential for adopting measures to address climate change. In view of these texts, it remains apparent that our country development and environmental protection are not irreconcilable aims. We therefore intend to continue our judicious pursuit of both with the full and effective participation of our citizens. And I want to add in conclusion too, that since taking office in August of 2020, our government has set as a priority the preservation and protection of the environment, while at the same time responsibly and sustainably, in a sustainable manner, explore and produce our natural resources to the benefit of all our people. And that is the mandate that was given to us as a government, and we intend to fulfill it to its fullest. We have so far ensured that the environmental permits are amended to ensure that there is a no flaring policy, and if there is flaring beyond the limit prescribed, that there shall be a tax or fee attached to it to ensure that there is no flaring. While many countries around the world are now making commitment to end flaring, Guyana has advanced in this area way before. We have also amended our environmental permit to ensure that there is cradle to grave management of waste, and that is critical. Treatment of water is critical, and to also ensure that environmental permits are made public so that anyone desirous of viewing these conditions and examining the conditions can do so easily. As a government, we will continue to work in the interest of our people, while at the same time protecting the environment at all costs. Guyana is a country that boasts high environmental credential, and this is something that we have prioritized as a government, and this is something that we are very happy with, and it is a commitment from our government that regardless of the development of our oil and gas sector and other natural resources, that the preservation of the environment, the well-being of our people, the protection of our people will remain paramount and key. So I just wanted to mention that in closing, and to say that we are happy for the opportunity to respond to comments in the correspondence and to bring some kind of clarity to some of the information that was mentioned in that correspondence of January 24th, 2024. Thank you.
Thank you very much, Minister. And now we have turned to the Commission for its reflections or questions, and then we return to civil society. Go ahead, Commissioner Caballero.
Thank you, Madam President. I'm going to speak in Spanish, but I would like to say hello to the state authorities and especially the human rights defenders present here by the Zoom platform. Yo estaba interesado.
Now, I was very interested in hearing what you had to say, and I'm concerned about the issues that have to do with defense on 3 issues. It's a question for both the defenders, the human rights defenders, and the state. The first has to do with what the authorities already told us, which is that there are means of transparency that exist. There is also a general interest or openness for people to be able to file actions against measures that might violate the right to an environment. And so I wonder if in these, given this broad standing, if someone feels that there's suffering a negative impact to the environment, can the state issue effective and broad injunctions that could suspend the right to an environment, while if there is some trial or legal proceeding? This is something I'm interested in. The second has to do with defense for the defenders. Does the state have mechanisms of protection for those who exercise the right to defend the environment and other rights? What mechanisms exist? What protection measures exist for defenders? It would be important to learn about that as well. And third, I ask whether in the long run the state can adopt strategies that recognize the right of the communities to protection of the environment in a more structural way, understanding that the companies come in, some wish to extract considerable resources, and there's quite a bit of money involved. But for example, if for populations that are especially rooted to the land, that might get some attention from the state in a more structural way in terms of ensuring and upholding rule of law and human rights. Those are my 3 points. Thank you so much.
Thank you very much. Commissioner Caballero, Commissioner Ralón.
Muchas gracias, Presidente.
Thank you very much, Chair. My name is Eduardo Ralón. I'm a member of the Commission, and I would like to extend greetings to the representatives of civil society and also the state. I think it's very important that we're discussing this issue in the context of this period of sessions. The information that you provide us allows us to be better informed, and it enables us to more appropriately address any situation that has to do with the right to the environment, the whole issue of human rights in business, specifically oil and gas activity in Guyana. I have a few questions. First, the first question is for the state. What measures has the state adopted to guarantee the right to information and the right to participation of the citizenry or stakeholders in relation to the oil and gas industry? In other words, how can they gain access to that information? How can they be taken into account to take stock of their point of view on a project that's to be authorized, or the negative impacts of a project that's already up and running? What channels of communication exist, and what channels for access to information? And the other question, which is more for the civil society organizations, you have denounced a number of situations here to the Commission. Legally, in Guyana, where can one file a claim? What mechanisms do you have available to you to be able to initiate a process or bring in action so as to correct some negative impact due to the oil and gas activity? How does it work? And where can you bring a claim for something to be corrected? That would be my question. Thank you very much, Madam Chair.
Mr. Ralón, I want to once again give some words of appreciation to civil society organizations that are participating here, as well as to the State Minister and other representatives. As I understand it from the presentation of civil society, and I have to say it was full of detail, and I hope that you all can send us the written version so that we can properly see it. Some of it went a bit fast for us to digest. But from what I was able to gather, it seems to me that there are three concerns that are being raised here. One, the question on due diligence for environmental management and environmental protection, whether or not all of the actions that should be taken to prevent environmental harm or damage to the right to healthy environment, are those actions being taken? That's the first question. The second question, a set of questions I understand around accountability. whether or not there's a state accountability or sufficient state accountability for actions which may be seen as violating the rights of citizens. So, for example, I understand from Ms. Elizabeth Dean Hughes, although there was some question of land, illegal entry onto land, and the question about whether or not there was a recourse or has been a recourse to address that illegal entry onto land. It's not clear to me, Ms. Dean Hughes, whether or not who entered onto the land, so maybe you can clarify that when you speak. So the question of accountability on rights violations, whether perpetrated by state or non-state actors, and then the question of the accountability by way of appeals processes. So we've heard there are two appeals processes in relation to environmental management. One, the Environmental Assessment Board, I hope I have that right, and the second one, the Environmental Appeal Tribunal. On the Environmental Assessment Board, the civil society representatives here are suggesting that that board may be not comprised of the level of expertise that is needed, or may be comprised of persons who may not be fully independent because of perhaps they may be representing the state in through their job functions. And then that the Environmental Appeal Tribunal has not been constituted. With regard to that, I want to ask the representatives of civil society. The minister has said, in fact, yes, the Environmental Assessment Board may not be constituted, but there are other recourse. There's other recourse for justice. There's access to court. So I would like to have your reflection on what do you think is the comparative advantage of a constituted environmental tribunal over a court? Is there a difference here that we should be paying attention to? And then the third area that it seems to me that is being raised by civil society, so to recount due diligence on management, accountability, and then the third big area seems to be participation. That civil society may not be fully included, or as components of civil society may not be fully included, and that the publics, in plural, may not have all of the access to all of the information that is needed to ensure that they can comment on state policy, and also that environmental defenders may be stigmatized. I think we heard you all speak about the language, the environmental defenders being called busybodies, for example. So certain stigmatization of environmental rights defenders. So for my question for civil society, I think I've asked you already, what is the comparative advantage in your mind in a specialized tribunal as opposed to access to courts? And for the state minister, I wanted to ask about the appeals processes. In relation to the Environmental Assessment Board, having regard to what civil society representatives have said, can you advise us on how the board is constituted so that its competence is assured as well as its independence? And then secondly, in relation to the Environmental Assessment Appeals Tribunal, what would be the mandate of such a tribunal, and are there plans to constitute that tribunal in the near future? Thank you. So we now give it over to representative civil society. And Ms. Radzik, I had to interrupt you in the first round, so you may answer the questions or you may start. I don't know how you'll want to arrange it, but you have, I think it's 7 minutes? Oh, 12 minutes, so you have 12 minutes. Thank you.
Thank you, Roberta. So in terms of the Environmental Assessment Board, with respect to the current 3 members and past, the problem we have is that all 3 members on what is supposed to be an independent assessment board are all high-ranking government officials, And it begs the question, therefore, of their independence, because they're all employed by government agencies. Also, in the Act, Environmental Act, there is provision for a 5-member board. And we have argued in the press and in the court that 5 members should be appointed to the EAB, the assessment board. And the 2 of those members must be professional, competent, civil society experts in environment, etc., in order to counterbalance and to establish a greater independence of this all-important EAB. In terms of the tribunal, Roberta, it doesn't exist. And yet, in the Act, provision is made for this independent 3-member tribunal. And we feel that, that in fact, if that existed, we would not have, what we have is only the recourse left to the to go
I'm sorry, we're not hearing Ms.
whereas the tribunal could be an interregnum should the EAB, scrap. You're not hearing me?
Yes, go ahead now.
Right. Yes, that the tribunal is the interim body that should be there for us to access prior to moving to the court. We move to the court now all of the time, but there ought to be on this interim. Finally, Section 11 of the Environmental Protection Act is specific in calling for an EIA on significant projects significantly affecting the environment. How can the minister say that projects such as massive offshore floating platforms drilling millions and millions of barrels of oil a day is not a significant project? How can they say that an establishment of a radioactive calibration facility with toxic chemicals, etc., situated in the middle of a long-standing residential area is not a significant project? These are things in the oil and gas industry that Guyana has never experienced before in our whole history. All of them deserve the merit of a professional and independent EIA. Thank you.
Right, and I would just like to speak a bit about the whole process. The minister, frankly, I don't think the minister answered any of our questions, and that is unfortunate. But when we come to the process in relation to environmental impact assessments, because that is what is there in the Environmental Protection Act. The other mechanisms he spoke about, those are not the main things that have to be done if there is a clear possibility that a project could affect the environment, right? And the process is that any project who wants to get an environmental permit has to do certain things. One is that they have to provide a summary of the project, right? The design and size of the project, the possible effects on the environment, right? Description of the project and a non-technical explanation of the project. This is written into the EPA Act of Guyana. Now, some of the companies I referred to in my presentation, they have no summary on the EPA's website. There is no summary. So how did they get an environmental permit when the process was not followed? And so there is nothing on the EPA's website. There is no project summary which speaks about Schlumberger's or Halliburton's, and these are 2 separate projects. They're not together. There is nothing that speaks about a mud plant, nothing. There are other projects that are on the website, but that is not. Tiger Rentals has no project summary on the EPA's website. That is the process. It is not there. And yet Tiger Rentals was the company from the beginning, right, who was responsible for dealing with hazardous waste. The environmental, the EPA's, their own form for hazardous waste is not there on the EPA's website. It does not exist. I had to find it in ExxonMobil's comprehensive waste treatment plan. Now, why, if what we Guyanese need, we are living in communities, and these oil and gas companies come and establish these projects within our communities, dealing with hazardous waste and other hazardous materials, right? And yet, that form which the public and people who live in communities should be able to access. There should be a report on this. It is not there. In fact, there is no annual EPA report since oil and gas came to Guyana. Prior to oil and gas, every year, the EPA had on its website, there was a report, annual report, right? So I just wanted to clarify that. There were a lot of questions asked. Mechanisms for protection for defenders of the environment. We have none. We would have to go to court about these matters, and that is it is difficult, it is expensive. We have to employ, or we would have to pay lawyers to do this. There's no mechanism available for defenders, which is not costly and time consuming when we have been attacked, as mentioned in this, in the presentations. And Liz, maybe you'd like to speak to your experience.
Thank you, Danuta. So I would like to corroborate Danuta with the Honorable Minister has answered none of the questions posed here, none of the questions posed in the 300 emails sent to the government of Guyana and ExxonMobil. So Roberta, to quickly answer your question, the people who entered illegally onto the land were the government of Guyana, Ministry of Natural Resources and Environment personnel, Ministry of Works personnel, ExxonMobil's ExxonMobil's onshore manager, and other ExxonMobil employees, along with the contractors, Geico and CSIN. Those were the people who entered illegally onto the land, and this is being done in a process where the registrar of deeds, who has been charged for fraud, has signed on annotated transport before the determination of a case which challenges the legality of the process. And quickly to refer to the minister's insistence that we have consultation, I'd like it to be noted that the residents in Canal Number 1, the letter has been submitted to the Commission. It was submitted to the EPA and ExxonMobil, objected to the fact that they were not consulted before in the consultation process. This was also admitted by ExxonMobil at their community outreach services after the submission of the EIA. So I would like to have that on record as a refute. And the minister talks about the gas leak management plan. Up to last week, I called the CDC, which is responsible for the oil management plan, and they were informed that they don't even know what is going on. In the press, we saw that different Middle Eastern countries were to help us with this plan. This plan is a necessity under Section 11. I will stop there so Karen can speak. The rest will be in writing. Thank you for the opportunity.
Karen, this is the red thread. Thanks, Liz. I just have one comment to make. Yes, there is in principle access to the course for some of the law breaking that is taking place, but I'm speaking from a constituency in which people have to make choices, such as whether they will be able to eat today or go to the doctor today. So in a situation like that, there is absolutely no likelihood of being able to file a case in court. As has been mentioned, court cases cost a lot of money. And just to reiterate, the constitution of the board of high-ranking government officials, our objection is not necessarily that they work for the government, but the objection is in the context of Guyana, there is a difficulty of independence and taking independent decisions that are in line with the work that you're supposed to be doing. As the notice said, mechanisms to protect human rights defenders. All we get is more abuse. I mean, Red Thread has been threatened in various ways, and we have got no recourse, not even from the police that we have made reports to. So that's I won't attempt to answer any other questions there. Thank you.
And if I could just also speak a bit about...
You only have 15 seconds, though.
Right,
Please.
access to information. That does not exist, right? As I said, the EPA's hazardous form, right, is not available. It is their form. It is not available on their website. How are citizens supposed to know that such a thing exists where we can see clearly what are the types of hazardous materials and how they are being used, right? And in terms of processes, EIA processes and consultations, et cetera, the EPA, what they do is they advertise a project and say there is this project happening.
Okay.
It's advertised in one newspaper on a Sunday.
I'm so sorry, Ms. Radzik, I have to cut you off. Unfortunately, we've run out of time, and we do have to be sort of rigorous and fair about the time. Minister, over to the state and its representatives for your response to the question from the Commissioner or anything else you wish to speak to.
Thank you for the opportunity to make some brief comments and to respond to a few issues that were raised before I hand you over to Mr. Bashram, who is the head of the Environmental Protection Agency, to deal with specifically in greater detail, some of the issues that were raised. I just want to state from the onset that it is the right of any citizen of Guyana to seek redress in the court of law, as has been happening and as was done by many of the civil society reps being represented here today. And I want to believe too that some of the contentions that are being made here, there were recent rulings, court rulings, on the very contentions that are being made here today again. So I just wanted to make that point up front to show that there is recourse through the court, especially with recent court ruling justifying the government's position and EPA's action. I am a bit baffled with regards to the comments, the acquisition of comments being made towards civil society activists. I can assure you that government has made no comments with regard or derogatory comments with regards to civil society activists. But what we do wish as a government is for civil society activists to be fair, balanced, and apolitical too in whatever they do in the representation of issues and the people at the same time. The other thing I want to mention too is that the EAB, it was mentioned that it's constituted by senior government officials. I want to say that these are senior professional public servants and not elected members of government, because it may come across as though these are elected members. They are not. They are professional public servants. Also, I wish to state that citizens of Guyana, they're given adequate opportunity in a consultative process. They're given adequate information via the EPA website, via the Ministry of Natural Resources, the Ministry of Finance, and many other portals that is available. I know for sure that before a production license is issued, there are several consultations being held, countrywide, of which many of the civil society activists present here today usually are in audience and would make comments at those very consultations too. I want to say too that this oil production that we speak of, it is actually 100 miles offshore Guyana, and it is not onshore. So I assure you there is no exploration activities onshore or within our land boundaries, but rather it is in the maritime space of our country. Now, there are many calls to stop oil production in Guyana, but we need to look at it realistically. We need to look at it in a way that a government has a responsibility to provide for its citizens. A government, especially in the context of climate change now and moving towards renewable, has a responsibility to ensure that we transition away from fossil fuel to renewable energy. We have a responsibility to our people to ensure that there is enough mitigation adaptation measures against climate change. We have a responsibility at the same time to ensure that there is economic and social development of our people and country. Now, the only way we can achieve this, the only way we can successfully achieve this is to ensure that we explore and produce our natural resources in a responsible, sustainable manner, and at the same time protecting our environment. And I think Guyana is a model oil producing country around the world now, especially with our high environmental credential. Finally, before I hand you over to the head of the EPA on the gas energy project, this is a project that will transform our country. This is a project that will reduce the cost of living. I think one person mentioned that, will reduce the cost of living of our people and improve the standard of living of our people by delivering reliable, cheap electricity, and in the context of climate change, cleaner electricity, cutting our emission for power generation by a 40 to 70%. So it is a project of national importance that will benefit all Guyanese either directly or indirectly. So I wanted to make those few comments before I hand you over now to the head of the EPA. Thank you.
Thank you very much, Minister, and thank you and good afternoon to colleagues and commissioners. Several issues, specific issues, were raised by our colleagues on the other side there in terms of the civil society members. And some of the questions raised by members of the commission, I will basically give an overview of the process of our decision making, and it will probably give you clarity on some of the questions that you've raised. So the Environmental Protection Act provides for, there's a schedule of projects that are listed in the Act that basically says those in those schedule, any project which may have significant impact, apply for an environmental authorization. And the agency, from the application and from its process of screening and site inspections, utilizing technology, utilizing the information that's provided by the developer or the proposer, makes a determination if the potential impacts may lean towards being significant or not. If it leans towards being significant, then the requirement, then and only then the requirement for an EIA is stated. No EIA, no requirement for an EIA is mandatory. It is at the discretion, it is at the discretion of the competent authority, which is the Environmental Protection Agency. Now, when an EIA is determined, and in all of the development projects offshore, from LISA 1 to the current one currently under consideration, an EIA was required. And as part of that process, the environmental impact assessment process is standard and is equivalent to any process globally. There is a notification in the newspapers, which the EPA publishes, saying that an EIA is required, and the public has 28 days to make written submissions for any questions, any queries they may have towards contributing to the development of the terms and scope for that EIA. Now, that is the only requirement in the Act, but the EPA over the years, at its discretion, held public face-to-face consultations across the entire region. And we're talking about the oil and gas sector here. And if you know the geography of Guyana, from regions 1 to 6, there were consultations, what we call scoping meetings. And it's open to any member of the public. The outputs of those sessions are the terms and scope based on the concerns raised at those meetings, which is developed with the EPA and a consultant approved by the EPA that is suitably qualified and experienced to conduct an EIA. When the EIA is conducted and submitted to the EPA, there is another statutory period of 60 days published in the newspapers again for the public to review those EIAs. The EPA instructs the developer to place those EIAs at key areas, key locations, to ensure that the public has access. And in fact, again, the EPA ensures that consultations, or what we call public disclosure meetings, are held across the regions again, explaining the results of the EIA and the findings. Now, all of that information coming into those EIAs are then submitted to the Environmental Assessment Board. The Environmental Assessment Board, independent of the EPA, reviews that. And if they require, they may seek or solicit additional expertise to support their decision-making and review of that EIA. The EAB then makes a recommendation to the EPA to say whether the EIA is acceptable or not, and what terms and conditions a permit or an approval should be granted if the EIA is found acceptable. The EPA then takes that recommendation from the EAB and decides to approve the project by issuing a permit. That permit then would also have specific measures, including recommendations received from the EAB, including recommendations that we would have heard and thought useful from the public in all of these consultations to ensure that adequate safeguards are in place if the project is approved by virtue of this permit. So throughout the whole measures, there are opportunities for public consultation, for participation, public participation. And that is a key aspect and tenet of the EPA's approach to ensuring when we are authorizing projects. After authorization, there is compliance, is another aspect. We are ensuring we have the capacity, we're talking about capacity of the EPA. It's not just about one sector of the EPA or one department of the EPA. It's building the capacity of the entire agency, from legal to engineers, technical to environmentalists, to public education and awareness specialists, to ensure that our full mandate is executed and ensuring compliance with the permits hereafter. So that is in a nutshell is the process and the procedures that we undertake to ensure that what we do is in keeping with the Environmental Protection Act. Thank you.
Thank you very much, Minister and representatives of the state. And so we are at the end of the hearing, number 18, on the impacts of private companies on human rights in Guyana. If you may allow me to just give a quick summary remark, it seems to me that there's quite a bit of agreement on the requirements, on some of the requirements for due diligence in the management of natural resources and to ensure a healthy environment. There's I think, certainly a consensus on that. There's a consensus certainly also on the need for accountability and also for accountability mechanisms, whether it's the court, the EPA, the Environmental Assessment Board or tribunal, but certainly that accountability is an important part of the framework of maintaining a good regulatory space for the monitoring of the use of natural resources and to maintain a healthy environment, and also the importance of participation of civil society based on a free flow of information. So I think that there's consensus on those principles. There is, of course, less agreement, and there seems to be substantial difference on whether or not those principles are being met or being implemented as effectively or at all, depending on whether you're a representative of the state or representing civil society. I only say that to say it's not for the Commission to make a determination on that, but to say there may be a way forward, and there always should be a way forward, having regard to the importance of civil society in ensuring state accountability. Sometimes it's uncomfortable, but that's the role of civil society in the maintenance of a democracy. And so we just urge, from the side of the Commission, we urge continued engagement between the state and representatives of civil society, and all representatives of civil society, not just those who are here. And we look forward to continuing to monitor the situation in Guyana and being available to the state and to civil society representatives for technical cooperation and engagement. Unfortunately, our Special Rapporteur on the Economic, Social, Cultural, and Environmental Rights was unable to be here with us today because he's attending another hearing. But we will give him a brief. He will have access to the recording of this hearing, and certainly, Minister, he will make an outreach to the state and to representatives so that he can follow up on any questions that require his attention. So with that, I want to thank you very much, everyone. Minister, you and your team, civil society organizations, and to the commissioners here. Thank you very much, and I now bring the hearing to a close.
Thank you.
period of sessions. The focus of this hearing is rights of women deprived of their liberty to reintegration. It is a regional hearing, as I understand it, and it will last for an hour and a half. And the purpose of the hearing is to provide information on the social reintegration of women deprived of liberty, as well as women released from prison, and in particular to provide data on violations of rights that they face, as well as discrimination, which affects how they exercise their rights. So before we begin, and we have an hour and a half for this, and as you all know, we will be organizing the hour and a half. You have, I guess, 30 minutes. Civil society has 30 minutes, and then the commission, if we have any comments, we have some minutes, and then we turn it back over to you for 25 minutes of response. Commissioner Rallon should be here shortly. But before I begin, I just want to do some advertising for the commission, or some celebrating on behalf of the commission, to say that we are in our 65th year. This is 2024 is our anniversary of 65 years since our founding, and the commission was and is committed, of course, to the defense and promotion of human rights, and we think that we have a record of achievement in those 65 years. And just to give you some statistics so that you too can be advocates for the commission, we have done more than 100 on-site visits, and for every on-site visit there's a report. Issued more than 1,000 precautionary measures, more than 750 merit reports, that's quite a lot, 220 friendly settlements, and we've sent 377 cases to the court. And all of this we do with victims as a central focus of our work and as our priority, but also our work through our technical advisory services with the state is meant to enforce or to support state accountability for compliance with the regional human rights standards. The other thing I want to say before we start is about accessibility, to remind you that this hearing, we are trying to make it as inclusive as we can in the framework of the technology. We ask all the participants to say your name, your position, and the organization you represent when you speak, before you speak. And every time you take the floor, please repeat it, your name, just at least your name. For those who are online, Zoom subtitles are available, and you can also expand the font or reduce the font, however it's suitable to you. And also, this hearing is accessible through the live stream on Facebook and on YouTube. So with that, I want to invite civil society to make its representation. I think we're supposed to have 30 minutes on the clock. Administrators, it says 20 here. Can we fix that before we begin? Okay. So 30 minutes, but remember, please introduce yourselves.
Estimadas y estimados integrantes de la Comisión.
Esteemed members of the Inter-American Commission on Human Rights, good afternoon. My name is Astrid Reyes, and I'm representing the Cyrus R. Vance Center for International Justice and the Network of Women in Prison, Red Mujeres en Prisión. The network is made up of 50 human rights defenders in 21 countries around the world who are devoted to examining the causes and consequences of the imprisonment of women and struggles to incorporate a gender perspective at all stages of the process. We're grateful to the Commission for convening this hearing on the challenges that formerly deprived of liberty women face when it comes to reinsertion or reintegration once they complete serving their sentences. This hearing is being held at a very timely moment, for the detention of women has increased in recent years around the world. At the same time, the socio-political situation in the region has become increasingly punitive, and we see examples where the detention of large numbers rather than reinsertion has become the main goal of the state. We applaud the report on women deprived of liberty in the Americas, in which this commission addressed many of the issues related to the effective reinsertion of women as they leave prison. We hope that this hearing will be able to follow up on the findings and recommendations of the Commission, while also giving visibility to the obstacles which will proliferate if states decide to follow a path of generalized criminalization. I'm now pleased to yield to my colleagues from the network. They represent 5 countries from across the region. As you'll note, unfortunately, one of the many consequences that our women colleagues formerly deprived of liberty is the difficulty of being able to attend international activities in person because of their criminal records. And while we can still have 2 of them participating virtually today, we really feel their absence in a space that truly belongs to them more than anything else. Thank you very much. Good afternoon. My name is Claudia Cardona. I'm the director of Mujeres Libres in Colombia. This is an organization, a women's organization, made up of women who have been deprived of liberty and who have directly suffered the issue and the violations of rights that occurs when one leaves prison due to the bad orientation of reinsertion programs. As my colleague Astrid has said, for those of us who were deprived of liberty, traveling and going through migration is an emotionally exhausting and anguishing experience. We've lost scholarships and other international opportunities due to difficulties obtaining visas and because of the exhaustive migratory checks when we go into other countries. This has resulted in unjust deportations and inhuman treatment. Having your entry denied, being stigmatized is constant. This anxiety is overwhelming, and in many cases, we are forced to yield our voice in these spaces. Next, I'd like to introduce a part of this issue, the activities that are carried out in prisons are limited to activities that do not give the necessary skills and that don't have a real focus on preparation for life outside of prison. Activities such as weaving, sewing, making bracelets doesn't prepare us for paid activities. These are stereotyped activities that keep us in historically undervalued, poorly paid, or unremunerated jobs, limited in one's personal job growth. The social stigma is translated into a lack of labor opportunities, impeding access to dignified work with fair pay and adequate conditions. The few women who have got jobs face workplace exploitation and gender violence by employers and colleagues, tolerating them male colleagues, tolerating them because of fear of losing their jobs or the need to provide for their families. Banks refuse to open up bank accounts, nor is it possible to gain access to loans or have a financial or to get a credit record so as to be able to get loans for our economic autonomy. There have also been situations in which public and private universities have refused to admit some women, even though they have met all the academic requirements and have paid tuition. The lack of programs to prepare one for life out of prison has left us and our families without the psychosocial support we need to take on the changes in our lives. When leaving prison, colleagues have found their families have been disintegrated because the ties have been broken due to the time in prison. Many women don't have a place to live once they get out of prison. They lack economic resources, plus they're not able to rent housing. This is a situation that requires that they live in unsafe places or places where they have experienced violence in the past by family members, partners, or ex-partners. In addition, it's known that medical care in the prisons is deficient, which results in serious health problems for us when we get out, and very few have the economic resources they need to gain access to medical care. Though they should be able to turn to public health, the complexity of the applications makes it difficult for them to gain access to the medical services they need. When it comes to access to a pension, those of us women who regain our freedom are at a disadvantage because the time worked in prison is not recognized as work experience. And even if one were to get a job and pay off the installments, we don't comply with the requirements of the system, and this leaves us exposed to having, in our old age, undignified conditions. Criminal records continue to, even though on the record, even though in Colombia there's a judgment of the Constitutional Court that says that the criminal record should not be divulged. But even so, it continues to be easy to access, and it is considered when one applies for a job, when one wants to lease to rent an apartment, and in the financial system. Even though the current administration of Colombia has expressed its commitment to human rights, we note that the state lacks an effective social strategy for transforming society. And that is an urgent need. That is why we propose exploring a technical assistance agreement between Colombia and the Inter-American Commission. I'm grateful for the opportunity to make this presentation, and we hope that conditions of a dignified life can be guaranteed for women deprived of liberty and those of us who have got out. Thank you very much. Distinguished commissioners, I am Teodora Vasquez in representation of Mujeres Libres of El Salvador. Mujeres Libres is a nonprofit organization made up of women who were deprived of liberty before, in which we seek second opportunities as a model of reinsertion for women who have served large sentences because of obstructive emergencies, miscarriages, among others. In 1997, the criminal code was amended, absolutely prohibiting abortion. This agenda, designed by both religious and civilian conservatives, which has for years marked the fate of women, considering any type of abortion to be an aggravated homicide without the right to any investigation that would allow them to clarify the context in giving rise to the emergency. The Salvadoran Constitution considers that life starts at conception, and this reform led to hundreds of women to prison for crimes they did not commit. The violence these women experience is considered a twofold conviction, because you have the conviction imposed by the judge, but then there's the conviction imposed or the condemnation imposed by society. When we finally regain our liberty, thanks to the tireless struggle to show our innocence, many of us women find that we don't have the accompaniment we need to be able to continue with our lives in freedom. It was in this context that Mujeres Libres arose, the objective being to accompany the processes of every woman, giving them better opportunities for reinsertion in society. Following up on procedures such as psychological accompaniment in shelters, accompaniment in physical health, scholarships, legal support, artistic and cultural offerings, enterprises or business undertakings, among others, which we consider fundamental in order to follow up on the reinsertion process. But to follow up on these processes, we discovered that it's a priority to follow up on the following steps. Women should not lose their ties with their children and close family members, so that when they regain their liberty, it should not be so difficult to reintegrate, and they should be able to find that support based on trust. We need sustainable opportunities that provide this immediate support for all persons who regain their freedom. It is very important that before a person regaining their freedom, that there be checking in with the family to see how many people will have family support, and whether it's necessary to bring a group psychotherapy. Also, the criminal records should be expunged immediately on regaining their freedom, so that people have greater possibilities of reinsertion in society. The partnerships should be established with companies so that they have immediate job opportunities, so as to be able to have economic autonomy. There should also need to be gynecological care protocols in the prisons to prevent infections, which can become very serious. There must also be dignified processes for older persons, those with chronic diseases and terminal illnesses as well. There should also be non-custodial measures for women who are pregnant or breastfeeding. There should also be an awareness-raising process to guarantee the right to comprehensive education on sexuality, both in the community and in schools. As Mujeres Libres, we continue to be committed to taking the initiative so that return to home can be comprehensive understanding experience, especially in a context in which criminalization has become routine without any emphasis on eventual reinsertion for those deprived of liberty. At the same time, we issue an appeal of solidarity and empathy for those women who at present are deprived of liberty, including women who have been unjustly detained by the state of emergency regime, for the minors who were born in prison, and for minors who were left as orphans. We're most grateful for your attention to this situation. We struggle to vindicate our rights so that persons who are being released can find immediate support. From Mujeres Libres, we are convinced that each of the issues spelled out need urgent attention so that our history not be repeated in future generations. Thank you very much. Thank you very much. I'm Andre Barrios from Colectiva Artesana, which is an organization that is made up 50% by women who have been deprived of liberty and human rights defenders in Guatemala. I will make reference to the situations that women face, social, workplace, and family context. As of December 2023, 4,182 women were detained, and 2,827 are deprived of liberty. And this is 12% of the total imprisoned population in Guatemala and in the region. Women, when they go to prison, are 18 to 35 years old, low income, without much schooling, single mothers with dependents. During the time they are in prison, one of the conflicts is centered on the presumption of innocence versus effective reinsertion. For the extended period of pretrial detention means that women are deprived of liberty with no reinsertion program for up to 8 years. There are no technical training programs or job opportunities. There's not a single state program or private initiative providing employment opportunities. The few jobs that people get are self-generated, and they reproduce gender roles. There are no psychoeducational programs to accompany women to help have a positive relationship with their children, which can harm the relationship and break the bond. The prison system discourages visits, especially to women's prisons. As we've been able to find in our ongoing work over 17 years, the prison system promotes leisure or idleness as a way of saving work. Women can be enclosed or confined for 23 hours a day. It's important to note that the prison personnel don't have any special training, and those in charge of the work area are guards. Women, once they're released, especially those who've served long sentences, suffer a sort of uprootedness, and even though no one wants to live in prison, it has become a safe place. And in many places, in many cases, they have better conditions than they will in the outside world, which has a negative impact on them, their emotional state, once they're released, because they're not prepared for the cruel, hostile, and discriminatory society they'll face. According to a poll we took, a survey we did of 200 former deprived of liberty women, when they left, more than 50% say that at present they don't have a job. 26% say that they are working in the informal economy, and due to lack of opportunities, the rest are thinking about traveling irregularly without papers here to the United States. Once they leave prison, women face the combined stigma of being women and being former prisoners, which becomes an obstacle to becoming reinserted in society. They suffer discrimination in access to work for having criminal records, independent of the seriousness of the crime and or the time that they have been in detention. They also have family conflicts, which in many cases lead to abandonment or loss of their family ties, inability to become responsible for their children, which causes great frustration and subjects them to different kinds of exploitation. As a national level measure at this time, we have a proceeding in the Court of Enforcement concerning effective social reinforcement for women deprived of liberty, so that the negative impact of imprisonment can be minimal in their lives and not be passed on to their children. Thank you very much. Good afternoon. I am Sonia Cabal of the Network of Nonviolence Against Women in Guatemala. The organization's that make up this network help work with women who survive violence and are human rights defenders. I'd like to state that for women who fought against corruption, impunity, women who defend rights but are persecuted by the forces that promote the breakdown of the rule of law and of judicial independence, well, for them, there is no reinsertion program to facilitate their reincorporation. After having been in prison, they're simply neglected, as though they didn't exist. For these women, the transition between life in prison and the outside world has not been easy. Being in prison meant that they survived the conviction of the repressive state, and on getting out, they have faced the stigma of society, the breakup of networks of support, of the social and family network of relations, and serious negative impacts on their physical and emotional state. Former judicial officers who had a career were not able to continue. They have faced limitations in their professional work because most continue to face political proceedings and a non-custodial measure. They've been stigmatized, discriminated against, deducing that they can be professionals and resolve their own reinsertion and rehabilitation. This is the case of Virginia La Parra, Samari Gomez, Claudia Gonzalez, Alice Moran, and Paulo Escobar, among others. Sebastiana Paula, a Mayan woman who spoke only Maya, when she returned to her home, she found desolation and the imposition of having to carry out a racist measure and patriarchal measure of community service of collecting garbage. Virginia La Parra, 2 years after getting out, was not able to, did not have access to her benefits or her salary until the day that she was arrested. The Nicaraguan women political prisoners who were exiled were denied the right to have a passport. Their properties were confiscated. They were stripped of their nationality. Their families are facing constant harassment and surveillance. For those who stayed behind in the country, they need to survive this surveillance, harassment, and general siege. They've been denied access to work, including being underemployed. They're constantly harassed, them, their children, and their family members. The main obstacle to reinsertion in these cases is that they have been deprived of liberty by the very state, and there's no attention to the problems that they are experiencing when they exit prison. We ask the Honorable Commission to take this grave situation into account, this situation that we're experiencing in the countries of the region. Thank you very much. Good afternoon. My name is Alejandro Ramos. I am greeting you on the behalf of X Justicia para las Mujeres. We seek to transform structures of power that generate oppression and exclusion for a wide variety of women. In Mexico, the National Law on Criminal Enforcement, when it was published in 2016, was considered progressive, but it continues to fail to observe the impact of imprisonment on women's lives. From the spaces that we share with women who have got out of prison, we are able to construct a concept that is far from the idea of reinsertion as a question of public security that is just again this constant suspicion that the person will be engaged in crime once again. Moving to an understanding that of how, the moment that women are free, they can go home in dignified conditions with autonomy, tranquility, care, stability, and health. We recognize that it's necessary that the state provide accompaniment, providing tools and guaranteeing their human rights. And we appeal on the state to be concerned with the long-term consequences that generate imprisonment because of the negative impact on their emotions, their thoughts, and their bodies. Recognition that there are services for women who get out of prison, post-prison services. That's also in this law, but the reality is that the reinsertion policy is implemented in the states on a differentiated basis and only gradually. According to a national survey of population deprived of liberty, only 2 of 10 women in prison know that there are government services to support them when they get out. Nonetheless, 90% of these women deprived of liberty indicated that they are interested in gaining access to these services. Specifically, we have identified some services that should begin to be sought from before the time a woman gets out of prison. These include identity documents, custody of their children, documents so to be able to follow up on the services that they received within prison, and protection for women who, upon their exit, face risk to their integrity and their life. Initially, the services require improvement so as to be able to take into account women's needs, such as access to shelter, clothes, transportation. The authorities also need to be able to inform them about what the services are. Finally, as regards the reinsertion policy, we find that there is some support that is conditioned. There are services such as doctors that are limited exclusively for those in prison. There's no specific legal counsel for indigenous women, and as mentioned by my colleague Claudia, the legislation does not sufficiently regulate the mechanisms for persons who get out of prison to be able to gain access to jobs with dignified working conditions. In particular, the lack of ID documents has a significant negative impact on the reinsertion process of women. This issue has been taken up by different civil society organizations and Mexican activists. Among those findings, we find, for example, that persons with a non-custodial measure in the phase of enforcement cannot gain access to official ID because their political and electoral rights are suspended. This has a direct negative impact on their possibilities for gaining access to other rights, for example, fellowships, government support, opening a bank account, and so on. In the case of women, many of them, since they're the main caregivers of their minor children, have a negative impact in terms of school enrollment or gaining access to medical services. These are just some of the problems and challenges that women in prison and formerly deprived of liberty and their families face in Mexico and in the region. Thank you. Good afternoon.
Mestre em Segurança Pública e também presidente da Associação Elas Existem Mulheres Encarceradas. A Elas Existe é uma organização feminista interseccional, abolicionista penal e antirracista que luta para visibilizar a situação das mulheres cis e trans afetadas pelo sistema prisional dentro e fora das prisões. Iniciamos nossas atividades dentro dos presídios em 2016, quando o Brasil começou a ocupar a terceira posição mundial no ranking de encarceramento de mulheres, atingindo a marca de 42 mil mulheres privadas de liberdade. É importante contextualizar que o Brasil, ao falar de encarceramento de mulheres, possui um dado assustador, como o aumento em 700% de mulheres encarceradas de período de 2000 a 2017. E as dificuldades desse número aumentam ainda mais pós-prisão. A situação do sistema carcerário Brasil não é novidade para essa corte, mas um outro dado assustador é que mais de 70% de mulheres encarceradas hoje encontram-se na sua segunda ou terceira prisão, ou seja, elas acabam retornando por conta das dificuldades da vida pós-prisão. Para encerrar essa minha breve exposição, gostaria de ressaltar que no estado do Acre, o coração da floresta amazônica, durante o ano de 2014, 100% das mulheres encarceradas eram negras. E em 2017, 97% eram negras. Nós da Elas Existem nos mudamos também para atuar no Acre.
We of Elas Existem have also switched, and now we are also active in the interior in Cruzeiro do Sul, and when we arrived in the city, there were 33 imprisoned women around the village of the Punayao indigenous people. After our work started, that number dropped to under half, which proves that any activities that focus on the mind, the body, and mental and financial tools, mental health and financial tools can decrease that number if we consider public policy for women after they are freed in order to contain that increase. Through our actions, we also try to raise awareness related to transgender women and travesti women, which are often invisible and not fully taken care of. I apologize for racing through.
Soy Viviana Rodríguez Peña.
I'm Viviana Rodriguez Peña, and I work with Corporación Humanas. I'm an attorney. We work on these issues. In my country, in El Salvador, Guatemala, Mexico, and Brazil, this situation described by my colleagues is just beginning to become known. But we are concerned how in the region we continue to consider that punishment and deprivation of liberty are the way to solve various social conflicts. With this outlook, we respectfully present 4 requests to the Inter-American Commission. First, to continue with the regional dialogue on women deprived of liberty, with specific spaces for women who were in prison and who are now facing this situation of stigmatization and barriers to reintegration to society, to learn about the initiatives in each country and identify good practices. Second, to collect the information provided by my colleagues to look into further to look into the situations in these countries so as to monitor them from a human rights standpoint and transmit these requirements and requests to the state's party. In this regard, include this issue of the reincorporation of women deprived of liberty to society in all monitoring activities of the Inter-American Commission, for example, in the course of on-site visits, in following up on the recommendations that are set forth in Chapter 4 and 5 of the annual report and in the country reports. We ask that the on-site visits of the Inter-American Commission guarantee a space of dialogue with women deprived of liberty and those who were deprived of liberty. The first opportunity will be April in Colombia. Finally, to have a monitoring instrument that will make it possible to monitor the progress made by each state in terms of the recommendations set out in the report Women Deprived of Liberty in the Americas 2023 report, establishing short, medium, and long-term goals, and especially alert to setbacks in the state's parties. We're grateful for your attention, and we are ready and willing to field any questions or comments you might have. Thank you.
Thank you. You finished before your time. This must be a record. So I would like to pass on to Commissioner Rallon, who is, amongst other things, also the rapporteur for persons deprived of liberty. But I think some of the countries here covered are your countries as well.
Muchas gracias, Presidenta.
Thank you, Madam Chair. Good afternoon. My name is Estardo Rallon. I'm the rapporteur for persons deprived of liberty. I would like to begin by warmly greeting all of you who are with us today from civil society, who are in person, and everyone who is with us virtually as well. I would also like to present some considerations and reactions to the valuable information you have provided us with. I would like to state that the Commission, this rapporteurship, has been under my purview in the first 4 years of my mandate, and now I have continued with my second period. And for me, it is a great honor to be able to support you in your fight in this very adverse environment you live in. In 2021, through the different monitoring and evaluation mechanisms and in preparation for preparing the report regarding women deprived of liberty in the Americas, we led an effort to reinforce, to strengthen follow-up of situations in this regard. That is, to take a look at women deprived of liberty and the differential impact on them, and analyzing their situation regarding their social reinsertion. In that thematic report, the ICHR asked or realized that there are very few existing programs. That is to say, there are no public policy actions that are actually working successfully in any country of the region. What we have seen is isolated actions, but especially everything is very precarious. Additional to a lack of programs, there is a set of restrictions on these persons because of a lack of resources in following up on the important role of the state in that regard. Additionally, in the report, we were able to see, and you were very helpful to us in that regard. You stated in the report, and you are saying this again in this hearing, that there is a set of difficulties in the transition between life in prison and life outside, and such as what you said, stigma, discrimination due to criminal records, lack of work opportunities, and also a loss of their social safety nets. As we heard in the plenary of the Commission, we established a new strategic plan for 2023 through 27. One of the priority areas in that strategic plan is regarding social reinsertion for persons deprived of liberty. This is something that is extremely important. It has to be disseminated because it's a priority in our strategic plan 2023-27. In the annual strategic matrix for 2024, we also have a priority set for this. All the inputs, all the information is valuable because we need to think of at the rapporteurship for persons deprived of liberty. We need to consider what are the next steps for the next report. And social reinsertion is a priority in our report and in the matrix for 2024. It is a specific priority. We would like to tell organizations that the communication that we have established, some of you have met virtually, and this is the first time we see you in person. Everything that is an input, not just for requests that I am taking note of and I'm fully committed on following up on, will be taken into account in these regional conversations and on-site visits as well. They will allow me also to analyze what are the next steps that the rapporteurship for persons deprived of liberty should be taking. This is a huge challenge, not only for safeguarding the lives and integrity of persons under our purview. That's not just it. It's we need to make sure that people can become reinserted into society, and not because they were in prison, they will not be able to go back to their life project. That is why I'm so thankful for the information you have provided us. So very quickly, I'd like to ask some general questions, and if it's possible, we'd like to hear the answer. What is your experience, or in your experience, how do you think we could measure, or in your experience, how could we measure a social reinsertion program? That is to say, how can we make sure through some sort of audit or some sort of metric to ensure that actually people are being reinserted into society? And also, have you identified good practices that should be of greater attention by us? These are my questions, and when we have met virtually and taking into account that we have an in-person visit, I would like to tell you personally that I really admire the work that you do. It is not easy work, and it requires a high level of sensitivity in such an adverse environment. And you, through your work, are really helping us at the Commission to do a better job. So thank you. That is all, Madam Chair. Comisionada tiene la palabra.
Much, and also to you, thank you very much for the presentation. It went almost quite quick, but the main points of your presentations, I think, hit home. And I do not want to be too long in what I want to want to go right into my question, and that is, I think the representative from Brazil gave us some figures. I was I'm really happy that you're here, because hearing Portuguese was like, there's no translation, and then there was translation. But what I appreciated from your presentation was that you were able to give figures, and the figures that I definitely wanted to know and want to know from you all that are here, if you have them collected, the data collected, are what is the impact on older persons? Because you alluded to it in some of your presentations, but you didn't go into detail. So what are the figures with respect to health in general, mental health specifically? And then the second part is, what are the figures with respect to African descendant women? Because the figures in Brazil are alarming, and I think they're representative of the figures across the region. So are we collecting that data, and do you have that data available? Thank you very much.
Special Rapporteur.
Muchas gracias, Presidenta.
Thank you, Madam Chair. And thanks to the petitioners for bringing this issue to the agenda of the IACHR. It's extremely relevant, especially what we have seen in the past few years, in the past decade or more. We have seen an increase in criminalization of women, and since we see an increase in the region, in the figures and the number of women incarcerated in the region, I don't have the precise data to make a concise statement about it, but I know that there are too many women in the region. I thank you for your presentation regarding how the social, cultural, and economic rights of women deprived of liberty are affected, and also once they are in freedom. And after going through this episode in their life, their socioeconomic and cultural rights are violated. I invite all of you to send this information to RESCA so that we can include it in our monitoring actions, which is something that we do regarding many topics, but would love to get this information from you so we can add this information to our reports. Thank you.
Thank you, Madam President. Buenas tardes.
Good afternoon. George Lima. I am currently the coordinator of Section 3 for coordination, which is the IACHR branch that is in charge of 3 rapporteurships. One of them is for persons deprived of liberty. I would like to take the floor right now, first to thank all of you, as some of the previous speakers did, because you brought this topic to this period of sessions. It's such an important topic. I also had wanted to mention 2 things in particular, but the rapporteur did so already. The first one is the importance of including this topic in our strategic plan for the next 5 years, and also, as the rapporteur just mentioned, in the actions matrix for what we need to implement this year. This is important because it shows the importance of the Commission, that the Commission gives to these topics, and to the support of the organizations too, that they can carry out with the Commission. As our rapporteur said, it's important to have open dialogue, and this is something you have been doing when you prepared your reports, and it's something that you have you have good open dialogue with Romina, who's a specialist. We urge you to continue with this dialogue so that we can include you in the activities for this year with the leadership of the rapporteur. I would also like to ask a complementary question to the questions that were asked already. Something that I personally resonated with me, and I was thinking about it, and that's regarding the criminal records. The rapporteur asked about good practices you identified. So my question is, have you identified good practices specifically for criminal records? And if you did, how you would think that that should be addressed, taking into account that, as the rapporteur just said, there will be a thematic report on the issue specifically about reinsertion, and something that the Commission will be issuing recommendations on this topic in general. Thank you, Madam Chair.
Very much, George. Thank you very much, representatives of civil society, for your elaboration, which was done with some passion and a lot of commitment to women's rights. This is the third time this week, in fact, that we've had reference to women deprived of liberty. The other two, in the context of our hearings and our working meetings, in one of them we heard the terrible story of a child under 18, a girl who was incarcerated, pregnant, who gave birth in detention, that baby was detached from her, removed from her immediately, and of course the baby shortly thereafter died, and she remained incarcerated for a year with many health complications, which she still lives with even after being released. And by the way, she's still under 18. So that was one. And then we had another hearing where was about persons deprived of liberty, and the conversation was about prison overcrowding and prison conditions. And we also heard in that hearing about women who are incarcerated, who are not receiving the most basic of provisions that we all need as women in the context of incarceration. So there is the prison conditions issue, and then of course there's the release issue, and you're speaking about the release. I was very also, I suppose, encouraged to hear the reflection on the kinds of skills building that is done in some prisons, which are very stereotypical and really do not prepare anyone for the world outside. You know, interestingly, that we're still teaching women about sewing and weaving and making bracelets. Now, I don't want to knock that. These are creative expressions that are quite wonderful, but they're not necessarily aligned to the labor market needs and the labor market opportunities. So you're incarcerated for long periods of time where you should be able to build significant skills and emotional intelligence and life skills. There's time for that. That's what you have when you're incarcerated, time. So how to use that time in a way that people are better prepared to be reintegrated, and also, given the statistics that you all presented, not sort of put themselves in a situation where they're re-perpetrating or re-offending to be reincarcerated. So I think really very important points when we think about reintegration. What is that? What are the skills building? What are we talking about? There's the psychological component of preparedness for life and community, and there's also the labor market component, the skills that we need and the capacities that we need. So I think that's something that we have to continue thinking about and helping states with. But also the whole question of family disengagement. It's still, I mean, the story with the baby is a very shocking one, but it is quite shocking that we don't understand the importance of keeping people integrated with their families, women and men, people integrated with their families whilst they're incarcerated, because it also helps the family to remain engaged. And you all have given some information, qualitative information about family fragmentation, because it's not just the person who's incarcerated who is away from her family. The family itself is experiencing fragmentation and dysfunctionality. So how do we think of the conditions or the services available to people who are incarcerated that keeps them connected to their family and keep their family stable. I think that so it's two sides of that coin. I also want to comment on the intersectionality. It was Viviana in the end who asked the big question that I'm always concerned about. Why is it that we continue to think that incarceration and deprivation of liberty are the main ways to solve social problems? And we know there's social problems because when you look at the population of people in prison, they have a certain profile. And I'm very happy that Commissioner Denise spoke about that. There's a certain ethnic profile, there's a certain age profile, there's a certain income profile. The persons who are incarcerated tend to be the most marginalized, generally speaking, of populations. So that's a social problem, and the incarceration just deepens that social problem. How can we think that there are some people who have to be incarcerated because, of course, your concern is the safety of the community. But for all of the others who don't represent a threat to the community, what may be the ways in which we can think about punishment, if we want to call it that, that doesn't divest them of their capacities to engage in their life, in their community and in their family and in their country. I think these are really big questions which Commissioner Rallon will not go away, because what we're seeing is an increasing of incarceration rates. I think there was, someone gave the statistic of a 700% increase between 2000 and another year, which I can't remember what it was, but 2000 and 2017. I think the 700% increase. So what we're having is an escalation of the problem, which also reflects an escalation of the social fabric disintegration. So we have to think carefully about that. I just maybe want to ask one question I didn't quite get, and I think it was from the colleague from Mujeres Libres. When you spoke about, I think you were talking about women who are incarcerated or convicted and incarcerated for miscarriages, what we call miscarriages in English. I don't know what you'll call it. I think you said abortion. And I wanted to understand a little bit more about what that is. Are women incarcerated for having obstetric emergencies? I just want to hear a little bit more about that and where that is happening. Thank you very much.
Muchísimas gracias a todos.
Thanks, everyone, for your comments and questions. I would like to just organize the answers. So I will begin with comments and questions presented by Commissioner Rallon. I think Claudia from Mujeres Libres Colombia will be able to begin with her answers. Thank you, Astrid. In response to Commissioner Rallon's questions, and then to give the floor and an opportunity to my colleagues, I wanted to say that in Colombia, we have been thinking as to how we can measure everything. This can be measured regarding the ability to have access to these activities. In Colombia, if a center has 2,000 inmates with only 800 opportunities for doing some sort of activity, then we have 1,200 women without opportunities. As I said in my presentation, these activities should be linked to their ability to sustain themselves when they leave jail. Just making little bracelets is not going to prepare us to have a job, pay for expenses, and have a home and everything that entails living outside of jail. And all of these tools should be used to measure the activities that women can engage in after they leave incarceration. Additional to the activities that they learn inside should be useful as long as they respond to the needs of the labor market. For example, SENA, which is a center where they provide free training for persons in Colombia, but They only teach inmates how to sew and make little bracelets and so on. They're not preparing them for the labor market. So regarding good practices, I'm answering two of the commissioners with this. In Colombia, Mujeres Libres has the first psychosocial support profile that is for women who are leaving jail, and we facilitate those courses. When we have worked with women with this protocol, we have seen that they're interested in this program because it's led by people who have been deprived of freedom, not only because they can trust us with their psychological support, but also in regards to training. But I wanted to say that we do have this care protocol in Colombia. And that's, I think, all I wanted to say. Thank you, Claudia. Our colleagues, Ale and Carol, also want to share something regarding good practices in their countries. Ale, please. Thank you. So talking about the efficiency, first and foremost, thanks for your response and for being so sensitive to what we do and for your responses. And now to my responses regarding effectiveness. As we said, there are many barriers to access, even to basic care, so that women, once they are outside of jail, they can have a life in society. So we're thinking first in reducing red tape for these women to have an easier transition. We need to consider how effective this could be if these processes begin before they leave jail. For example, they can have access to an ID card before they leave jail, so that as soon as they leave, they will have access to their rights. That's a first indicator of efficiency. Also, measuring whether or not they have access to general services that are available to the population at large, such as healthcare, education, labor opportunities, and training, and as Gloria said, psychosocial support, which is also important, support networks. And if there is to help these women overcome the challenges in their reinsertion. A good practice that I'd like to highlight is the fact that institutions that are designed for social reinsertion cannot be linked to penitentiary systems, because it's as if this woman has to be going back to the same authorities, though women who went through a very difficult process in their life, having to deal with these authorities once again, to have to face them again, is difficult. And many women in general will not want to go back to have access to these services because they are fearful of going back to the institution. So these services have to be separate from the penitentiary system, so that women can participate, and women should participate in all the process, in the design, in the evaluation, so that women who are deprived of freedom and women who are free should be included at the discussion table. Thank you.
Muito obrigado.
Thank you very much for your comments. It's very important for anyone doing the work that we do, being from civil society, for us to be in a place like this and to be hearing the comments such as the ones you made. That just strengthens us and inspires us to continue fighting. It gives us the encouragement for us to forge ahead in this effort. So I thank you. Now, as far as the comments made and the questions asked, I'm going to do this the Brazilian way and to try to organize this information and talk a little bit about what we do, what my organization is doing, so that I can give to you some concrete, practical examples of what you've asked about. Brazil, you can see that there has been a considerable rise of women in prisons, and many of them are there for the second or third time, and the fact that there are not effective public services to help these women when they get out of prison to actually survive outside. So that's what we try to do within our country. Acre, the state of Acre, is the last state in Brazil. We went to the last city of Brazil, Cruzeiro do Sul. We went to that prison. There were 33 women, most of whom black, young, who were there for the third or fourth time. And we understood, we learned from them that every time in this small town, as Cruzeiro do Sul is, every time they got out, everyone knew that they were ex-inmates, and no one wanted to give them jobs, give them a second chance. And so we wanted to offer informal educational practices to them, to teach them how to solve certain problems on their own. Teach them, for example, how to do manicures and to braid hair. This isn't an informal way, but it is a way to bring the women together, to get them involved, from thinking about their physical well-being and their health and their emotional well-being, because we can't think about these good practices if we have to accept or understand the fact that within the prisons they have acquired certain vices and fears and habits, and so we have to care for their bodies and minds and to help them this way integrate into society. And working with women when they are still within the prison population, within this prison, we understood that, saw that trans women oftentimes, when they were released, just went back to the streets to prostitute themselves again, and they even had that much more of a hard time finding jobs because their only solution was to go back to what they did before, to prostitute themselves. So this is a very important topic, and I know I went over my 4 minutes, but I understand that it's very important for us to also approach this with informal training and teaching of practices of what might seem like minor matters, but in a small town, they're that much more in the spotlight. And so the issue of gender is important. Transvestites and trans women also need special differentiated care, because when we speak of women, we often think of cisgender women. And so you have some women, trans women, who are in male populations, and they almost always go back to the street. So social reintegration entails thinking about some very specific things as well. So I thank you for the opportunity to speak with you. I hope you will be able to go back to Brazil again, and we can continue talking.
Sí, con relación a cómo medir la efectividad en el caso de...
In terms of how to measure effectiveness in the case of human rights defenders, journalists, judicial officers, there's no specific program, no experience. Nonetheless, what should be done is to restore the rights that have been violated. That is what is needed. And that criminalization should not exist. One will gauge effectiveness insofar as the states don't repress the rights that are enshrined in our constitutions and also in international human rights law. Thanks to all who have spoken. Okay. Yes, I think thinking about good practices, there are things that my colleague from Colombia, Claudia, has mentioned. There are things that the organizations have mentioned, and I think that good practices often focus on what the states do, but as we have seen, there's not really an interest in these issues on the part of the states, and so these organizations that have worked on these issues are needed and who are taking the initiative to make these proposals to the state. And so we insisted on opening up these spaces for an inter-American conversation with these organizations that can provide more specific examples. The second thing is, I can tell you that Colombia is beginning a judicial reform process in which this debate on what do we need to feel justice rather than simply imposing penalties, that is something that we want in this reform. But there's a sensation that we're very much alone in the region. And that is a concern when we see a social response to issues such as drug trafficking and citizen insecurity. Indeed, corruption. Everything, we're critical of everything being geared to imposing penalties, not because these issues don't need to be addressed, but we also need to see how the individuals are impacted, the families, the social networks, and even the community. The other thing is that the region is thinking about non-retributive, more restorative forms of justice. So the dialogue needs to be not only with the states once again, but also thinking about how we women also look to other ways to feel safe that is not the same as the classic model of the state. Finally, in terms of social and cultural rights, there's been a major effort on the part of the organizations to seek to bolster the sexual and reproductive rights of women, both inside and outside. 5 years ago, we weren't even thinking about this, and increasingly, yes, women are working on these issues. And the organization Mujeres Libres in Colombia also has experience in that work, also looking to the question about health that was put to us. And I would leave it at that with these comments. Thank you so much. I'd like to thank everyone. Evidently, we have quite a bit to say on this issue, and we'd be pleased to provide the Commission with more information in the future so as to continue this conversation. But for the time being, I wanted to yield the floor to our colleague Theo, who is going to talk about the law that criminalizes miscarriage in El Salvador, so that she can provide a bit more context and also to speak a bit about the impact of prison on older persons. Theo? Thank you very much. I was raising an issue where I was talking about the importance of older persons to receive dignified treatment, as well as persons with chronic and terminal illnesses. In El Salvador, since 2019, when the pandemic began, to date, it is unfortunate that women generally don't receive any family visits, women in prison. And this has a direct negative impact on older persons, for it is lamentable that the Ministry of Health doesn't collect data on the current situation of women in prisons. Now, with the state of emergency regime, where the prisons are more crowded, the situation has become all the more complicated. We don't have data. And we, as Mujeres Libres, make an appeal to the Inter-American Commission to investigate this issue. And we, as Mujeres Libres, are ready and willing to provide support as necessary, in any aspect necessary. Now, regarding miscarriage, it was said that there is legislation that that criminalizes abortion. Spontaneous abortion, literally translated, is miscarriage in Spanish. So it's it's independent of whatever kind of whether it's a miscarriage or an intentional abortion. So many changes are taking place. Some women have been sentenced to 30 to 40 years. It is said now that public schools Well, it's prohibited in public schools and public spaces to talk about sexual and reproductive rights, and this makes things all the more complicated for the community organizations that are working for better opportunities in society. This is regrettable because, as was said a moment ago, there are hundreds of women who have gone to prison for crimes that they have not committed, and the less information there is in society, the more such emergencies that happen to women are criminalized. So that is my comment. To answer the question about older adults, I am going to make reference to the Chinchi Sandoval v. State of Guatemala judgment by the Inter-American Court regarding the failure of the Guatemalan state to carry out this judgment, to comply with this judgment. And that has led to a process that we have begun in the Court of Enforcement to duly enforce the judgment, and the 872 older adults in Guatemala are not receiving any attention. Of these, 58 are women. We have 700 persons with diabetes. 5 women have suffered amputation of their limbs, of their lower limbs, as the result of poor diabetes care. And we have the serious problem of having 5 physicians to cover 26,000 people, and 2 assigned to administrative work, so that's 3 physicians. And the statistics of care provided by these physicians and care for women is the 7th or 8th place. They don't provide health care for women, not even preventive. In the Chinchín Sandoval judgment, the issue was older adults, disability, and health situations. And in the case of Guatemala, these are matters that have yet to be addressed. Thank you. That's it. Thank you very much. I'd like to thank everyone, and also Carol, if you want to say a little bit more about the data related to Afro-descendants in the prisons.
As I said, in 2014 in Brazil, 100% of black women, or rather 100% of women in prison in the state of Acre were black women. In 2017, in the second report, and that was the last report because in 2018, new president took office, and from that point on, we were in a situation that also impacted the prison system. But in 2017, not only in Acre, we found 97% of black women, of women in prison were black, but in the state of Maranhão and Tocantins also, 90% of women in prison were black. So we understand these are black women, they are young women, and beyond that, this number is increasing dramatically. So the total number of women in prison is increasing, and the number of black women in prison is also increasing. One of the things that we have heard today has to do with giving birth. And in Brazil, poverty used to be criminalized. Today, poor people are criminalized. So women who are poor, who live in favelas, who are also mothers, and oftentimes are accused of being the bad guy's mom. That's a very common expression in Brazil. So when we talk about motherhood, of separating mother from child in prison, whether they are pregnant and about to give birth in prison or before they are imprisoned, how can we recover their role as a mother? Because they end up suffering a triple punishment because they are women, because they are an ex-inmate, and because they are a mother. And we need to understand that racism is also at work. These are primarily black women. So we also need to highlight how we understand that imprisonment is only increasing the challenges these women face. And when they are finally freed, they suffer a triple stigmatization, especially in the case of Black women.
Thank you. I'd now like to give the floor to Claudia to talk a little bit about criminal records and share some examples of legislation throughout the region, relevant legislation throughout the region. I just wanted to take the opportunity. We had been asked about the antecedents criminal record. In Costa Rica, there's a law that allows judges to expunge criminal records for those who live in vulnerable situations. I don't know where that law stands right now, but we know that it exists and that it could be a good practice for the region. So I just wanted to leave it there. And there was a good practice in Colombia for the region regarding incarceration of women, and that's our law 2292 of 2023. Next March 8th, it'll be 1 year since that, and that is the law on non-custodial measures for women. Services, public services for women heads of household, where women, instead of being in prison, are leaving now to provide a social service to the community, and they can be exercising their care work and the work of providing for their families, of course, with any number of issues and violations that we face when we exit prison. These are things I've already said, but the law is allowing for that alternative to imprisonment. I didn't want to conclude my participation without making reference to the law on public utility. Thank you. Thank you. And I think that Andrea is now going to say a few more words about the impacts on the families and the communities after a woman goes into prison. Thank you. I just want to make reference to the fact that in 2015, we were right here talking about the situation of children and adolescents with family members deprived of liberty. This is a population which up until that time was completely invisible and continues to be invisible if you look at it from the standpoint of state policies. They don't consider, for example, when searches are carried out, and this is one of the main issues that adolescents and children have mentioned in terms of the impacts they suffer from the first moment of detention and how they have suffered discrimination and stigmatization in two places where that sound paradoxical, which is at school and at church and in the community, and how they're pointed out, as they say in their testimony, because being the brother of a thief mean you must be a thief as well, or when they visit their family members in the prisons, how they suffer being poorly treated when there are body checks and the conditions when they are received at the prisons. This is an issue still pending for the services that provide child children, social services for children don't recognize this as an issue they need to address, and it's also a debt that the prison and the police have when it comes to guaranteeing protection of rights, considering that they don't have to do with the situation that their adult family members face. And this is a challenge we face in the whole system, so that their human rights are protected. But thank you so much for according this issue the importance of having this hearing, granting this hearing.
Much, representatives. That was a really, I think, very engaging hearing. Commissioner Ballon, would you like to say anything in closing?
Perdón. Sí. Quisiera.
Yes, I'd like to say, by way of closing, I would like to reiterate that we can continue this communication. The rapporteurship is precisely assessing the next step, and the perspective that you've brought to this hearing on social reintegration, reinsertion, is a priority. And I think it is a key point that has been abandoned in the structuring of public policies in the region, and it could be an important next step for the Commission to give voice to organizations such as your own as to what's being done, suggestions about where to go, and this suggests a line of action for public policy. It's also good that the rapporteur for Economic, Social, Cultural, and Environmental Rights is also here, who already spoke, but many of these issues have to do with the need to address economic, social, and cultural rights, as well as the understanding of the interdependence or intersectionality of the different factors. That was very interesting, and so we have a great deal of work to do. Thank you so much, and my congratulations for how you have presented your points at this hearing. Thank you.
Thank you very much, Commissioner Rallo. And it's just left for me to sum up and say thank you. But in relation to the clarification from Peri, from Mujeres Libres, just to say on the question of criminalization of obstetric emergencies, or as we know it in English as miscarriages, there are very clear inter-American standards on this. And the case from, you're all aware of the case from El Salvador, the case of Manuela, where the court, the Inter-American Court on Human Rights, called for ordered El Salvador to adopt structural measures towards banning the criminalization of women due to obstetric emergencies. This is a firm standard. It's not at all in dispute. And so I just really also want to send my solidarity to those women who've had to suffer this terrible injustice and inhumane treatment and have to live with the stigma of it. I want to also recognize a number of recommendations that have been made. We've heard the recommendations. Viviane, I think you summed up the recommendations for the representative of civil society, that we should continue the dialogue around the report, but to continue that dialogue with women who are also particularly affected by incarceration, who are also seeking reintegration, that we should continue to collect information and look at the specific countries where these are issues to monitor the implementation of the recommendations. I think that was a specific recommendation, and I think that's a good one, Commissioner Rallon. And then the dialogue with those deprived of liberty, women deprived of liberty, and monitoring the progress made by states in compliance. So we will have a review of the recommendations, and I think you will send them to us as well, so that we could consider how that can be woven into the strategic plan actions. So it's just left for me to thank you very much for your heart, for your thoughts, for your contribution to social solidarity and human rights. Thank you very much, and I bring the hearing to an end.